Okay, just let me know if the screen is visible.
Yes, sir, it's visible.
Okay, so we have already studied the boilerplate clauses, um, which were some of the important boilerplate clauses. Now we are going to study some of the general boilerplate clauses, which are not so important, but you can find these in the agreements, and uh, these are generally not negotiated much by the parties. First one is the entire agreement clause. This is although not negotiated, but it is a important clause because what this clause does is it supersedes all prior agreements. So let's say if you have an agreement, current agreement in force, and you agree to certain terms by way of an amendment, and you want those amendments to be superseding the previous one. Let's say you are agreeing to commercial clauses which are entirely different from what you had agreed earlier. Then in that case, you will definitely include this clause. The purpose of this clause is to ensure that the rights and obligations are in one contract and they supersede all prior discussions, negotiations, agreements, whether they're in oral form or in writing. So, let's say you have negotiated and agreed to a contract, but because of some reason you want to cancel that and want to have a different one. So in that case, the second one will supersede the previous one. And in the interim, if you had any oral discussions, oral representations, they will not form part of the final written contract. Then they are also superseded. So if parties are entering into more than one contract, then you should always remember that whether you have to include this clause or not, it becomes relevant. It may not impact implied terms which are based on custom or usage because they are more or less not captured in the contract. But in any case, if you are superseding those implied terms by way of a written contract, like disclaimer clause, where you are disclaiming all implied warranties, then in that case, it is important that you include this clause in that contract. And if you are not very sure, then in this clause you can also refer to the previous agreement that is being superseded. So let's say if you have a lease agreement and instead of a renewal there is a break and then you want to do another lease agreement, then it's better to have a reference of the previous lease that you are superseding that lease. Next clause is the notice clause. This is quite common clause, and the purpose of this clause to inform the parties what is the acceptable mode of notice. Earlier, it was very critical when there was no form of communication other than by physical letters. But now we have, in addition to physical letters, we have emails and even courts accept notice by way of WhatsApp. So maybe parties will only agree that email notice is sufficient, or sometimes, despite the availability of best of communication tools, they would want that the other side give important notices by way of written letters or registered post. So that can also be a agreed form. Sometimes people would like to include the when the notice is deemed as served. You may have heard of and read about the acceptance of contract. But similar to that way, when we say, let's say we are saying that notice to be served by a registered post, or let's say if the parties are in uh, two different countries, then in that case you may want that the notice is uh, served, but sufficient time is available with the other side to respond to it. So you may say that if it is by way of international courier, then the other side gets 7 days time. So you will say that the notice will be deemed served after 7 working days it is sent by the first party, because the other party cannot wait for a very long time. The first party cannot be challenged on the ground that we have not received a notice. Once a notice is sent, then it is presumed that it is delivered. And sometimes the physical address and email address, etc., also may be included in this clause. Next clause is waiver. This is a very generic clause. You will rarely find any negotiation around this clause. So it specifically says that unless a party waives its rights in writing, then a waiver will not be considered as a waiver. It may also say that unless if a party has given a waiver once, that doesn't mean that it will waive the same condition twice. So the purpose is to ensure how the waivers will be interpreted, how these will be interpreted under the contract, and the parties reserve their right for general non-waiver despite the prior specific waivers. And they may state that only express waivers in writing are valid. Next clause is invalidity or survival clause. This is also something that parties rarely negotiate. The purpose is to specify which of the clauses will survive termination. This clause is important because you may want some of the clauses like indemnity, warranty, or post termination warranties, specifically those for the works which a party has already performed, they survive the termination or expiry of the contract. Some common examples of clauses that may survive is confidentiality, indemnity, limitation of liability, a governing law or dispute resolution clause containing an arbitration clause. For invalidity, we'll come to the severability clause. Next is the amendment clause. So, an amendment, as it says, basically any amendment to the contract will be valid only if it is in writing. Otherwise, any oral amendment won't be considered, or let's say an amendment by way of email communication, that won't be valid unless it is put in writing and signed by the authorized signatories of both sides. Uh, any amendment will include a variation, modification, or partial termination. Next is severability. Severability clause is to ensure that in case a clause is held invalid by a court, then how the parties will treat such situations. So they will say they will either renegotiate the invalid clause and replace it with a similar clause having similar intent, or they will say if no such intent can be found, then it will be treated as that it was not never a part of the contract. What this does is that only that particular clause which is considered invalid by the court is taken out and rest of the contract survives. So this is an important one, but this is a legacy clause, and again this is something which parties don't negotiate often. Audit clause is something that you may want to have in your contract if, let's say, you are an insurance service provider, or if you're a financial service provider, or if you're maintaining accounts for a client. In this clause, it is used to ensure that the contractor complies with the financial terms, they are maintaining accounts, and they're ensuring compliance with clauses. In IPR license agreements also you may want to have this clause. These clauses are also found in distribution agreements or licensing agreements, as I said. Next is assignment clause. This is somewhat negotiated but not very extensively. Assignment is different from another legal term known as novation. In assignment, only the rights are transferred in a contract to another party. So let's say if I am a service provider and you are a client, and as a client you have an obligation to pay me, then you can assign your rights but not the obligation to pay me. Similarly, if I have a right to uh, pay you, but as a contractor, I will have a right to receive the payment. So I can assign that part to a third party. But again, I cannot assign my obligations, that is to perform the service. So, if parties are in a position where all rights and obligations have to be transferred to a third party, then in that case we have to use novation. Novation is nothing but assignment of all obligations as well as rights to a third party from a particular date. So, from that date, the third party becomes liable towards the first party, and the second party gets released from the contract. But in such cases, a written contract between all three parties is required. In case of assignment, there is usually a prior consent requirement, but there can be an exception for an assignment to a group company or to an affiliate company. Next clause is relationship. So in contracts where like you are having the contractor's manpower, then you may not want that manpower to claim an employer-employee relationship with you. So you may want to include this clause to ensure that no employer-employee relationship is created, no principal-agent relationship is created, and whatever contractor is doing on your behalf is only as per the contract, and the contract is on principal to principal basis. That is, both parties are responsible for their conduct. Next is confidentiality clause. Um this clause is negotiated partially, but this particular clause is more or less standardized, and not much negotiation may happen except for a tweak here and there. For example, you may find a confidentiality clause also having reference to personal data or a sensitive information like proprietary information. So that's all in this lesson. Now we will move to some sample clauses. Any question? Okay, these are some of the examples which I have taken from publicly available contracts. These may differ from contract to contracts. The idea here is to let you know about the gist of the clause. So the entire agreement clause. This clause says the transaction documents, together with the exhibits and schedules thereto, contain the entire understanding of the parties with respect to the subject matter hereof, and supersedes all prior agreements and understandings, oral or written, with respect to such matters, which the parties acknowledge have been merged into such documents, exhibits, and schedules. So, what this clause says simply that the document, including its exhibits and schedules, are the entire agreement between the parties, and anything written or oral which is prior to this agreement is superseded. Notice clause is very simple, so I'll skip this one. Going to waiver. No provision of this agreement shall be modified, waived, or discharged unless the modification, waiver, or discharge is agreed to in writing and signed by the employee and by an authorized officer of the company other than the employee. Another example is no waiver by either party of any breach of or of compliance with any condition or provisions of this agreement by the other party shall be considered a waiver of any other condition or provision or of the same condition or provision at another time. So these are two ways you can say this clause. One is that this agreement and any waiver to this agreement will have to be in writing and signed by both parties. And second one says that if a waiver has been granted, it doesn't mean that waiver is presumed for the second instance. Next is the survival clause. The respective representations, warranties, agreements, covenants, indemnities, and other statements of each of the issuer guarantors, their respective offices and initial purchase set forth in this agreement, or made by or on behalf of them pursuant to this agreement, shall remain in full force and effect, regardless of an investigation made by or on behalf of any issuer, guarantors, officers, etc., and delivery of any payment for the notes. So this is a little different clause specific to this particular agreement where a purchase sale of shares is happening. But if you look at the second one, the respective agreement, covenant, indemnities, and other statements set forth in section 6, 9, 10, 15 hereof shall remain in full force and effect, regardless of any termination or cancellation of this agreement. So this is a very standard clause found for survival clause, that these particular sections of the contract will survive any termination or cancellation of the agreement. Then the amendment clause. The agreement may be amended or modified only by a written instrument signed by the executive and by a duly authorized representative of the company. So, this is a way of writing and saying that amendment has to be in writing. Or if you remember the earlier part, uh, this second clause, yeah, the first one, no provision of this agreement shall be modified, waived, or discharged. So you can also say another way that any amendment to the agreement or any termination or any modification has to be in writing and signed by both parties. Going to severability. In case any one or more of provisions contained in this agreement shall for any reason be held to be invalid, illegal, or unenforceable in any respect, such invalidity, illegality, or enforceability shall not affect any other provisions of this agreement, but this agreement shall be construed as if such invalid or illegal or unenforceable provision had never been contained herein. Upon such determination that any term or other provision is invalid, illegal, or unenforceable, the court or other tribunal making such determination is authorized and instructed to modify this agreement. This is unique to this highlighted part is unique to this particular contract, but in Indian context, courts will not get into such determination. They are not there to replace the contract clause. They will simply hold the clause invalid or illegal. So in this case, the alternate language would be that the parties will modify this agreement and replace this particular clause so that the original intent of the parties as closely as possible is retained. Next is the audit clause. Each party shall have right upon reasonable advance notice. This is quite important. For all audits, it has to be advance notice and at his sole expense. So, whoever is conducting the audit has to bear the expense of that one. and during normal working hours. So this is again another important aspect of audit, that it has to be during working hours. To examine the records of the other party to the extent reasonably necessary to verify the accuracy of statement, charge, or computation made pursuant to this agreement. If requested, a party shall provide to the other party's statements evidencing the quantities of products delivered or provided hereunder. If any such examination reveals any inaccuracy in any statement, the necessary adjustment in such statement and the payment thereof shall be made promptly, and shall bear interest at the late payment rate from the date of the overpayment or underpayment was made until paid. So basically, if there is any discrepancy is found due to the audit, then the other side will be penalized for that. And what is not mentioned here is that sometimes parties will say that the expense of the audit will also be borne by the defaulting party. Now coming to assignment clause, neither this agreement nor any right, interest, obligation hereunder shall be assigned by any of the parties, whether by operation of law or otherwise, without the prior written consent of the other parties. Subject to the preceding sentence, this agreement will be binding upon, inure to the benefit of, and be enforceable by parties and their respective successor in sign. So, this second part is the qualifying part, and it says that for assignments, you need to have prior consent from the other side, but in case there is a successor, your successor, or your assignee, then in that case it will be enforceable against them. The agreement will be enforceable against those. The qualifying statement that can be included here is that in the first sentence it may say that the assignment won't be without prior written consent of the other party, but such consent not to be withheld unreasonably or delayed. So the onus is also on the first party not to deny such assignment unreasonably. Coming to relationship clause, the relationship of the parties to this agreement is determined solely by the provisions of this agreement. Parties do not intend to create any agency, partnership, joint venture, trust, fiduciary, or other relationship with duties or incidents different from those of parties to an arm's length contract. So this is relevant here in case you want to have a arm's length relation or on a principal to principal basis, then this is what you have to include. Coming to confidentiality clause. Any confidentiality clause or agreement will have one statement which says what is confidential information. Another statement will say that the receiving party will not disclose it and keep it confidential. And it will say that what is not included in the confidential information. What type of information is not a confidential information? These are known as exceptions. So if you read this A, B, C, these are the exceptions. So something which is known or becomes known to public other than as a result of breach by the receiving party is or has been independently developed or conceived by the receiving party without use of the disclosing party's confidential information. It may also have a qualification that the receiving party's records may have to show it. Third one is or has been made known or disclosed to the receiving party by a third party without a breach of any obligation of confidentiality. Such third party may have to the disclosing party. So a third party may also provide, for example, uh, if I as a company has given you my confidential information and you are sharing it with your, let's say, affiliate or a subcontractor under a NDA, then in that case, that may be allowed. Some other exclusions may include where the disclosing party themselves have authorized such disclosure. there is also a proviso which says that the receiving party may disclose the information to their attorney, accountant, consultant, or professionals so that their services can be performed in relation to the transaction. These are specific ones, two, three, four, for this particular type of transaction. But the idea is that the confidential information can be shared with a contractor or an employee or a director on a need to know basis so that they are able to perform the service, and there may be a qualification that they are also subject to a confidentiality agreement which is restrictive in scope as much as this particular NDA. And if they are not, then uh, the information cannot be shared with them. And the obligation on the receiving party would also require that they maintain the confidentiality of disclosing parties' confidential information with the same level of protection that they employ for their own confidential information. So I suggest you read some NDAs to get the idea how NDAs are formed, because this is the first document that you will get. And the definition of confidential information, the exceptions, the permitted recipients of confidential information, these are some of the important clause of an NDA or a confidentiality clause. Any questions so far? No? Okay. So in the next session, we are going to discuss the general clauses or the clauses, boilerplate clauses, which are not so important and part of contracts, which are not much negotiated. So, I think, let me ask you,
Yeah, hello, sir.
yeah,
Sir, now I don't have any question,
mhm,
but I want to know, sir, how should I discuss, sorry, how should I practice or after going through this cloud, this document or this or such template.
mhm, okay. So, the easiest way is to find some sample contracts and you identify a particular section. Let's say you have identified an assignment clause or a notice clause. So, see how differently those contracts have written it. Some contract may have a simple statement. Let's say in case of notice, it will say that both parties agree that the notice has to be given to the other side by in writing, by email to the other side, and service by email is sufficient, and it will be considered as a service on next 24 hours once it is sent. Some may say that notice is served after the email read receipt is received by the first party. So, different types of constructions of clauses will be there. If you look at more complex contracts like share purchase agreement or EPC contracts, they will have a very detailed clause on notice itself. Although it's a very simple clause, but they will say that the notice has to be given to a particular person, and with the notice they have to explain the requirements also in detail, provide supporting documents, all those things. So depending on the context, the type of contract, the parties, it will vary. So that is a good way to learn, because practically you are not working in any organization, then you may not get such ideas.
So, so, so I am So I think you are suggesting me to explore different kinds of contracts and try to read and
Compare.
understand them.
Yes, yes.
Okay.
Second way is to read development, legal developments in the relevant area. So let's say if it's a very substantive clause like uh, governing law, arbitration, like indemnity or warranty. So you should read legal articles from law firms, or I had given you two websites, Mondat and one more. So on those
Exactly.
websites, you will have those articles. So you can see the development. For example, if you look at the guarantee or warranty clause or a bank guarantee clause, how it is related with the insolvency law, how
Okay.
what will happen that if you have taken a parent company guarantee and the parent goes insolvent, or let's say the company goes insolvent but the parent is solvent, so will you have a claim against the parent? Will that parent company guarantee clause survive or not because of the insolvency of the contractor? So these are some areas where I think the website is having some technical issue. I'll look into it. Let me show you the YouTube channel.